The probate process in California is oftentimes unpredictable, but our office has handled over 1,000 probate court matters, and as a result, we know our way around the process. Now, the average probate takes about 12 months, and the costs and fees vary depending on the case. And in this video, you'll learn a more in-depth breakdown of each phase of the probate process. Phase 1, initial intake. Phase 1 takes about 10 days or so. Once we've talked with you and received a fully completed intake sheet, we'll open up a My Case client portal for you where you can communicate with our firm, electronically sign documents, sign the initial retainer agreement, and keep track of every aspect of your case as it goes along. And once your intake sheet is received and the retainer agreement has been signed, we'll begin drafting your paperwork to begin the court process. In most cases, very little, if any, money is due up front. Phase 2, getting the petition signed and filed and setting the first court date. Phase 2 takes about 45 to 60 days. Once all the initial documents are drafted and approved, the documents will be sent through My Case for an electronic signature. Once the signature has been received, the documents will be filed with the court. The court will then give us a court date 45 to 60 days after that. And during this time, we'll give notice of the hearing to all those who are entitled to it by law. Phase 3, first court date and issuance of first court order and letters. Phase 3 should take anywhere from 1 to 3 weeks. With the paperwork filed correctly and assuming there is no objection, the petition to appoint you, our client, as the personal representative of the estate will be approved at the first hearing. The court will then issue a document called letters, which empowers the administrator or executor to wind down the deceased person's affairs, including paying off or negotiating debts, selling assets, and placing proceeds into an estate account until the probate is complete. We always get our clients full authority to avoid needing a court approval for the sale of real property, such as the deceased person's home. Phase 4, 4-month creditors period and appraisal. Phase 4 takes about 4 months or longer in some cases. Once the letters are issued, a 4-month creditors period begins. It's during this time that the now appointed personal representative will have the ability to pay debts, collect assets, apply for a tax ID number, and sell any real property that applies. The creditors will have to file a claim with the court during this time to be paid, and it's also during this time that the court appoints a probate referee to put an independent valuation on the estate's assets, including the real property. Phase 5, final report and accounting drafting. Phase 5 typically takes about 30 days. At or near the end of the creditors period, assuming all assets have been sold or transferred and all debts have been paid, the final report and accounting will be prepared for filing with the court. The final report and accounting allows the court to review and approve all steps taken by the personal representative and allows for an order of final distribution. Once that's drafted, the report or accounting is sent to you through our My Case client portal system for an electronic signature and then electronically filed. Phase 6, filing the final report and the final court date. Phase 6 usually takes 3 to 4 months. When the final report and accounting is filed, the court will set a final court date usually 3 to 4 months after it's been filed to review and approve it. Assuming there's no objection or procedural issues, the court will approve the accounting and sign an order for final distribution on or shortly after the final court date. And finally, Phase 7, final distributions and orders for final discharge. Once the final accounting is approved and we receive the final order from the court signed by the judge, our office will prepare the final receipts for all the heirs or beneficiaries to sign. The court wants to make sure everyone gets what they are entitled to based on the order of final distribution, and the receipts are how we do that. Once the receipts have been signed and final distributions are made, the court can now discharge the personal representative from their role as personal representative. And that's it. That's the process. We hope you feel like you now have a better understanding of how probate works and how long it should take. And if you have any more questions, feel free to reach out and ask. This stuff can be complicated, but we're here to help.